Hello, everyone. I'm Ruth Young, a legal writer with Grossman, Young & Hammond, and this video is going to be about the recent changes to the USCIS policy manual relating to O-1 visas. In September, USCIS released changes to their policy manual, which is used by USCIS officers in adjudicating petitions for immigration applications and benefits. Certain sections of the policy manual are confidential and aren't released to the public, but other sections are. This video will discuss the changes that USCIS made to the policy manual about O-1 petitions for non-immigrant workers of extraordinary ability. This includes the O-1A subcategory for people with extraordinary ability in science, business, athletics, as well as the O-1B category, which is for artists and also for workers in the motion picture and television industry. I'm here with Sofia Hassander. She's an associate attorney at Grossman, Young & Hammond in our Silver Spring office, and she focuses on employment-based U.S. immigration, including O-1 visas, which we'll be talking about today. Thank you for joining us, Sofia.
Hey.
So, Sofia, tell us, what are the biggest changes you observe in the policy manual about O-1 petitions?
Well, there are two important policy changes people should be aware of. First, there's a new strong emphasis on instructing officers about the totality of the evidence test. As some viewers may know, the O-1 regulations require that in order to qualify for an O-1 visa, you must be able to show that you have either been awarded a major prize in your field, and then we're talking prizes such as a Nobel Prize, an Oscar, or a Grammy, or you must satisfy at least 3 other regulatory criteria from a list of criteria. And some examples are performance in a critical role for distinguished employers, serving as a judge of the work of others in your field, or receiving high compensation as compared to others in your field. In addition to satisfying these regulatory criteria, O-1 petitioners also have to demonstrate that on the whole, the beneficiary qualifies for O-1 status by meeting the relevant standard of extraordinary for their particular category.
So what is the particular standard of extraordinary for O-1A and O-1B petitions? I guess they're different?
Absolutely. For example, the standard in O-1A petitions is that the beneficiary has sustained national or international acclaim and is one of the small percentage who have risen to the very top of their field. For O-1B petitions, there are 2 different standards. For those in the arts, the standard is that the beneficiary has sustained national or international acclaim and has achieved distinction in the field of arts. And for those in the motion picture and TV industry, the standard is a record of extraordinary achievement significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, or leading in their field.
So how does this relate to the totality of the evidence test you mentioned earlier?
Well, when reviewing an O-1 petition, the USCIS officer should first look to see whether the beneficiaries satisfy either the major price criteria or at least 3 alternative regulatory criteria. If the officer is satisfied that the beneficiary meets the criteria, they should then consider the totality of the evidence to see if they're extraordinary on the totality of the evidence.
So this is not a new requirement, the totality, is it?
No, it's not a new requirement. The regulations haven't changed, but there's an increased emphasis on relying on the totality of test when making the decision, for sure.
So that definitely tracks with what people are reporting about the increase in requests for evidence and the lines of questioning in requests for evidence in O-1 petitions, doesn't it?
That's true. Many immigration attorneys, including our firm, are definitely seeing a change in how USCIS is applying the totality of the evidence test.
So what does the policy manual have to say about how USCIS officers should apply the totality of the evidence test to O-1 petitions?
Well, in fact, the policy manual doesn't give much guidance for officers, only that they must apply it to their satisfaction. Here is the quote from the manual to give you an idea. The evidentiary requirements are not the standard for the classification, but are instead the mechanism for establishing whether the standard is met. Accordingly, the fact that the petitioner has produced evidence satisfying at least 3 evidentiary criteria does not necessarily establish that the beneficiary is eligible for the O-1 classification. Rather, USCIS must determine eligibility based on whether the totality of the evidence submitted demonstrates that the beneficiary meets the relevant standard.
All right, thank you for that information. Now, Sophia, why don't you tell us a little bit about the second important change to the policy manual that you mentioned?
Certainly. The regulations that list the criteria that an O-1 visa must satisfy includes a provision for submitting comparable evidence. As for many occupations, the criteria listed are simply not applicable. Well, this is also not new. There wasn't any guidance previously about as to when a USCIS officer could consider comparable evidence, and the result was a lot of inconsistency. According to the new policy manual, for comparable evidence to be considered, you must explain why a particular criteria listed in the regulation is not applicable to the relevant occupation, as well as why the submitted evidence is comparable to that criterion. And of course, comparable evidence can only be used when a particular type of evidence does not apply to the beneficiary's occupation. It can't be used when the type of evidence does apply, but the beneficiary just doesn't satisfy it.
So can beneficiaries can people applying for O-1 status in all kinds of occupations use this comparable evidence provision?
Beneficiaries applying in the O-1A and the O-1B arts category can make use of it, but not those in the O-1B motion picture and TV category.
All right. Well, thank you for walking us through these changes to the policy manual about O-1 petitions. And thank you.
My pleasure.
Thank you. And thank you everyone for watching. If you are considering applying for an O-1 visa, or if you've received a request for evidence about a pending O-1 petition, please do not hesitate to contact Grossman, Young & Hammond to set up a consultation for more information. Thank you again, Sophia.
Thank you. Bye-bye.